Good evening, everybody. Thanks so much for coming. Tonight we're having two speakers. I don't know who's going to go first. Danielle? Okay, we have Danielle Higgins from the Ketterer law firm who's going to speak to and about legal aspects for small business. Get ready with your questions for her. And we also have George Buzzy, who's head of TECHUDSON here in Hudson, and he also is the entrepreneur in residence at Jumpstart, and also at YBI, Youngstown Business Incubator. So he's a busy guy and has lots of knowledge. I want to call your attention to the list of programs we have for this fall, and remind everybody that on Friday, October 18th, it's the deadline for our first annual pitch competition, with $3,000 is the first prize, $1,500 is the second prize, and $500 for the third prize for the best small business technology idea. So without any further ado, let's give these guys a warm welcome.
All right, can everyone hear okay? In the back? I think that I'll go ahead with my presentation, and then George will give his, and then we'll sit down together and have an opportunity for questions at the end. I'd like to begin. Thank you all for having me. My name is Danielle Higgins. I'm an attorney with Ketterer Law Firm. We are a full-service law firm with offices throughout Northeast Ohio. I work primarily out of our Hudson office, which is just down the road next to Rosewood Grill, and also our Canton office. And I specialize in corporate securities, capital raising, and I work with businesses of all sizes. I'd like to thank you for having me this evening, and I will bore you with the legal basics for 30 minutes, and then you can listen to George tell you about the fun stuff on pitching to investors. But to get started, I tried to frame this in a way that would help give you just an overview of some of the factors that you should be considering as you plan to raise capital, whether it's through private investors, whether it's through commercial loans. You know, these are sort of just some of the fundamental considerations that you need to take into account when you're starting your business and growing your business. So I think that fundamentally selecting the appropriate business form is something that, you know, entrepreneurs often send their articles down to the Secretary of State and then maybe don't necessarily think about some of the other legal issues that arise when you're thinking about starting your business. I think that at this point, 99% of business entities are divided into two primary categories, either an LLC or a corporation. The LLC is right now probably the most popular form, simply because it provides a little more flexibility than the corporation. Corporation, the structure by law is very regimented. There are requirements that you just have to comply with by statute, whereas the LLC provides a little more flexibility. More of it is dealt with by contract in your operating agreement by the members. And I've also broken down for this purpose S corporations and C corporations, and that's basically a tax designation. C corporations are, you know, what you think of traditionally as, for example, a large public company. Those corporations pay corporate taxes, and then any profits are passed through to the shareholders as dividends, and then the shareholders are, you know, also taxed. So it's sort of a double taxation situation. For many small businesses, an S corp is preferable simply because it avoids the double taxation, and you basically have a pass-through tax entity, whereas all of the profits and expenses and credits and losses that the entity incurs are passed through and reflected on the individual shareholders' tax returns. An LLC is also very flexible, and if you have a single member LLC, if you're the only person, the only owner of your business, by default, you're a disregarded entity for tax purposes, and your expenses and profits and losses just show up on your regular 1040 personal tax return. If you have 2 or more members of the LLC, the default is being taxed as a partnership, but you can also elect to be taxed as an S Corp. In terms of the form of equity, both S and C Corps utilize stock or shares. One of the primary differences between the two is that a C Corp allows for different classes or series of shares. This can be attractive for investors because they will often, your founders might have common shares, and you might set up a separate series or class of shares that are preferred, and they might have preferential liquidation rights. They may earn a right of return on their investment, and just you're able to structure it so that they have a different set of rights as the founders. S Corps, the downside is that there's only one class of stock permitted, and really the only division is that you can have different voting rights. You could have maybe a non-voting and voting class of shares in the S Corp. LLCs, again, are more similar to C Corps because you can pretty much structure it any way you want. You can have series LLCs, which have different tranches for different rounds of investors. They can really be as complicated or as straightforward as you'd like. So the LLC provides a lot of flexibility in that respect. In terms of organizational documents, they all require just your basic filing of your articles with the Secretary of State. Both C and S Corps generally you've put together a bylaws or a code of regulations that just governs the general corporate practices of the organization. For LLCs, you do an operating agreement, which is similar to a bylaws or code of regulations, but it's more contractual in nature as opposed to a governing document. It's more of a flexible document that's a contract essentially between the members. And in terms of liability, all forms, your liability is generally limited to the amount of capital that you contribute. In terms of management, both types of corporations are governed by a board of directors, and the directors then appoint officers to, the traditional positions of president, treasurer, secretary, whatever officer position your corporation decides to appoint. And the board of directors, of course, can have various subcommittees and can delegate certain decision-making activities to those subcommittees. An LLC, the members are sort of the analogous form to the shareholders of a corporation, and members can either manage the company themselves, they can delegate a manager to handle certain management functions, and that person or persons can be a member or just be a third party that they delegate. Officers are optional. Sometimes you'll see the managers or a board of managers will just handle all of the decision-making functions. So it's overall quite flexible with the LLC again. I think one of the next considerations to think about once you actually have your business form in place is actually observing corporate formalities. And I think that this is a point where a lot of entrepreneurs start to get a little sloppy. Maybe you have an attorney put together your initial articles and an operating agreement, or you pull one off the internet and call it a day. But if you're planning on going to investors or going to a bank for commercial financing, they are going to want to see that you've followed corporate formalities, that you're holding your annual meetings, that you have resolutions or actions by written consent of your managing body to make big decisions. It's across the board. Even if you're working with different types of situations. I had a client who was getting certified as a female-owned business, and they want copies of all of these organizational documents and all of the meeting minutes and everything for the past however long the business has been in operation. And if you haven't been keeping up on doing all of those things, it can create a situation where you're trying to backtrack and put things together and make things up that you didn't do at the time. So I always advise clients to make sure you're just on top of those types of formalities, getting your resolutions together, holding your annual meetings, that type of thing. Even if you're the single business owner, there may be a situation down the road where it would have been helpful to have been doing that along the way. Another point, certainly establishing separate bank accounts from your own. This can be an issue on a lot of levels, but you can possibly be held personally liable for obligations of the company if you're writing checks and depositing checks for the business in your personal account, and that there's not defined transfers from you to the entity. If you're going to contribute capital or additional capital to your company, you want to make sure that it's documented either as a debt contribution in the form of a loan, or that you're contributing additional capital for additional equity, and then that would be reflected in your capital account. So just keeping close track of your accounting records and keeping the accounts separate is important. Also, entering into contracts in the name of the company is important. It's something that we see entrepreneurs not pay that much attention to initially. You don't want to sign contracts in your personal name. It should be your name, your title, and the company. Conceivably, if you are just signing, Bob Smith to a contract that you're entering into on behalf of the company, you could possibly be held personally liable. I think another point to highlight is just understanding your fiduciary duties as a business owner to your other business owners, and particularly if you have a situation where you actually have an equity investment from investors. Fundamentally, the duty of good faith and fair dealing requires you to just act in a way that you believe to be in the best interest of the company. It's not a crazy test. My law school professor used to say you just have a stack of documents supporting your decision and no smoking guns laying around that were clearly adverse to the decision you made. In corporations, directors, officers, and majority shareholders owe this duty, and in LLCs, it's managers and members. And this is just, everyday sort of decision making that you want to just take into account the decisions you're making, and have a document trail, and possibly rely on advice from your accountants or lawyers or consultants when you're making decisions. The duty of loyalty is sort of the second layer, and this comes into play in situations involving conflicts of interest. For example, if you own another business and you want that other business to provide services to a separate business that you have an equity investment in, stealing business opportunities. If you own an interest in a real estate development company and you find another great opportunity, you can't just form another entity and sort of leave your other members out in the dark and capitalize on that opportunity without first presenting it to the existing business. And similarly, competitive business falls in that category. And I think the main thing here to keep in mind is disclosure of whatever the issue is. If it's a self-dealing issue where you own an interest in another business and want to contract with another business you have an interest in, that conflict of interest is fully disclosed to the board of directors or your other members, that the terms of your agreement are commercially reasonable, that there's arm's length negotiation. You just don't want to give yourself a preferential advantage that you wouldn't have if you were dealing with just a third party. And similarly with the business opportunity issue, again, you present the opportunity to the company if they aren't interested in capitalizing on that opportunity, get it in writing that they don't want to, and you can proceed. Another important aspect of starting your business and attracting investors is protecting your technology and IP. There are several classes of intellectual property, and so we'll just walk through and give you kind of an overview flavor. I will tell you I'm not an IP lawyer. If you have a business that is technology heavy, or you have an idea that is technology heavy, I would highly advise that you seek an IP attorney who practices in that specific field, particularly if it's something that is eligible for patent protection, simply because there's such a wide variety of patentable ideas and technology and information out there that you want to have someone who's very familiar with your particular industry and can help you. First, I'll talk just for a moment about trade secrets, and this is just any type of proprietary business information. It can be your customer list, your marketing strategy, formulas for certain products, and this is actually protected under Ohio law. And the term of protection is potentially indefinite. It's basically as long as you keep the information secret. And again, the only requirement here is that the information remains secret and that it provides you with a business advantage. Patents, as I mentioned, there's a variety of types of patents. A utility patent is probably the one you're most familiar with if you work in the manufacturing industry or technology. This is processes, machines, goods, compositions of different things. So this is, I think, by far the most common type of patent. There are also design patents. There's plant patents. If you make a hybrid of two plants that have never been put together before, you can get a patent for that. Again, in terms of the requirements, it's just a new, useful, non-obvious, and proper subject matter, and the term of the patent protection is 20 years. And I guess one thing to note that some people don't necessarily take into account is if you have an idea that or have developed a product that is similar to something that already exists and has existing patent protection, there is patent protection availability for improvements upon existing patents, of course. So it's in that circumstance, it's very important to find someone, an attorney, who's very familiar with that particular area that can not only advise you on how you're able to word your patent application so that you don't infringe on the existing patents, but also to make it as broad as possible so it makes it more difficult for the next person coming along to obtain patent protection. Copyrights are, original works. They're generally books, musical compositions, that type of thing. They last for 70 years, the author's life plus 70 years, unless you're a business entity that holds the patent, then it's 95 years. Trademarks are based on consumer recognition and goodwill, so logos, sayings, words, sounds. If you think of all the brands that are out there that have just a little icon or logo that signifies their company, that's where, that's probably trademark protected. I would just note that confidentiality agreements are critical in several situations, and again, this is something that you can work with an attorney on, or even potentially draft yourself, but you want to make sure that you have confidentiality agreements in place so that when you're hiring employees, working with suppliers and distributors, you're not inadvertently disclosing information. And I think finally, I'm way over time, that this is just a couple of additional points of advice that I would suggest, and I'll turn it over to George for his discussion.
Now can you hear me okay? There, okay, good, thank you. So I want to talk about two things tonight. One of them is kind of the lay of the land here in Northeast Ohio with respect to funding sources. And then the other half of my discussion is going to be about actually putting together a pitch deck. So just by a show of hands, how many people here either have an existing business or have a business idea in which they think they're going to ask outside people for money? So most everyone in the room. Okay, good. So traditionally, the most common way of raising initial money for your business is friends and family. So people you know who trust you, and but that's not always a luxury many people have. But it's usually a good place to start because, at least here in Northeast Ohio, a lot of the funding sources aren't so keen on funding just an idea. It has to be past an idea. And I'll talk about that a little bit further. So there is a landscape here of funding sources that are out of nonprofit organizations and then equity sources. So most people tend to start with the Glide Innovation Fund, which is Lorain Community College based. It is a fund out of Lorain, but it is not for companies in Lorain. It's for all 21 counties in Northeast Ohio. And the entry-level point for that fund is a $25,000 grant, so you don't have to pay it back. And then, but it's very competitive, and I'll come back to that point. After you've gotten the $25,000 grant, you can go back again. It's called the Glide Innovation Fund. And then they have a $100,000 loan. If you win this award, you don't have to pay it back. I think it's for 5 years, and then you start having to pay it back after that. There's no personal guarantees, but you do have to have a $100,000 match. So it's essentially a $200,000 project you would be putting before them, 100 from them and 100 from some outside source. If the business is located in Cuyahoga County, there is a fund called the North Coast Opportunity Technology Fund. And you can see that at the Cuyahoga County website. That is a $125,000 loan also, but that does have a personal guarantee. And one good thing about that, if your business is in Cuyahoga County, that counts for the $100,000 match for Glide. So it is quite common for someone to win the Glide B Award and then go on and compete for the North Coast Award, because the two come together and make up a nice $200,000 project. So everything I've mentioned so far is what they call non-dilutive, meaning no one's taken ownership of your company. You started off with 100%. If you were to go through this round of funding, you would still own 100%. Everything I'm about to say going forward is dilutive, meaning each time you raise money, you're going to have to give up a chunk of your business. These nonprofit funds, although they're designed to spur entrepreneurial activity and growth and all of that, there's way more demand than there is money. So they're very, very competitive. The Glide typical round is every 3 months, and on average, there's about 45 companies competing for 6 or 7 awards. So it's really the farthest along and the most well-developed business plans that tend to get funded. The good news is you can keep coming back, and there's no time limit as how many times you can come back to all of these funds. So after you've kind of gone through Glide, and if you are in Cuyahoga County and you did North Coast, the next traditional step was the Jumpstart Venture Fund. That was $250,000 on a convertible debt instrument, which means you either have to pay them back the money or they can convert to equity in your company. That fund is now closed. And they're opening a new fund, a for-profit fund, starting this fall, which is going to be around $1 million of investment, sometimes higher, sometimes lower, but on average about $1 million. But they're only going to do 4 or 5 investments a year. So that means that that bar is pretty far raised. After Glide 100,000, the next nonprofit fund out there is $1 million. So you can be sure that the 4 or 5 deals a year they do are going to be very, very competitive. And then typically following the Jumpstart Venture Fund is the North Coast Angel Fund. That is 100% equity, which means you're probably going to have to give up roughly, and it's a sliding scale, but roughly 35% of your company for the North Coast Angel Fund. And that is somewhere between a $250,000 and $500,000 investment. After the North Coast Angel Fund, now you're kind of getting into the venture capital world. And unfortunately, there are no venture capital firms anymore here in Northeast Ohio. They've all have been fully invested and no longer have capital to disperse. So you're kind of charged with going to Detroit or Pittsburgh or one of the 2 coasts to get venture capital funding. But venture capital now is a very high bar. The product has to be built. You have to have beta customers. You have to have a strong competitive advantage, and you have to have some level of revenue in the company. The company doesn't have to be profitable, but it has to be way past a good idea to attract venture capital funding. So that's kind of the funding lay of the landscape. Supplemented through all of that, and at any point in that continuum, are private angel investors. These are high net worth individuals typically that either you know or someone you know makes an introduction. They tend not to work well for cold calls, so you really do need a warm introduction to get in front of an angel investor, particularly somebody who's done multiple investments. They're particularly guarded about who approaches them, and they like to be introduced by someone in their network who they trust. Typical angel investors probably going to invest somewhere between $100,000 and $250,000, and they're going to want to take an ownership percentage of your company, and they're going to want to be on the board and have a say in decision making. They tend to be very good partners. If they like your space, most angel investors only invest in companies that they are familiar with, meaning they've already owned 2 or 3 companies in that space, or they came from that industry and have since retired, or they had a number of exits. So they tend to invest where they're comfortable. You won't see a manufacturing angel investor investing in a software company, typically. That's not always true, but typically that's the case. They stay within their comfort zone. So that's the kind of the basic of where the money would come from for your business. One thing I always like to counsel entrepreneurs on is the national average of an entrepreneur who owns 100% of their company. By the time they raise these various levels of funding, including venture capital and maybe even a second round of venture capital, by the time that company is sold for an exit, they end up owning 14%. So you as a 100% shareholder of your small business need to understand a couple things. One is you're not going to own 100% or even 51% as you raise money from strangers. And you're going to have to understand that owning a small piece of a big pie is bigger than the whole small pie, and that everyone wins if you bring on the right partners. Also, most entrepreneurs tend to be very subject matter specific, meaning they're not necessarily good CEOs. And it's very common for angel investors and venture capital firms in particular to insist that you take a chief technology officer role or some other role other than CEO, and somebody who has built a company, grew it, sold it, been there, done that before, is going to be the person leading the company. That is not a fact. It's not 100% of the time, but from my experience, it's a good 90% of the time that the founder is typically not the right CEO. So if you're sitting here saying, I'm never going to not be the CEO and I'm never going to give up control, that's a fine position to take, but you're also never going to get outside money from strangers. That's just how it works. So I talked about that gap between Glide and Jumpstart and North Coast. So that area of funding after 100,000 and before 1 million, the Youngstown Business Incubator is going to be starting a seed fund sometime within the next 6 months. And that'll be another source of capital here in Northeast Ohio. Average investment will be between $100,000 and $200,000. It'll be an equity-based investment. It will not be a loan. It will not be a convertible debt instrument. It'll be pure equity, much like North Coast Angel Fund would be. But that isn't available yet. Danielle mentions about LLCs and C Corps. The most common corporation I see out there is an LLC, and that is pretty much what everyone does. But you should know that if you ever go to a venture capital firm to raise money, they're going to insist that you become a C Corp. Venture capital firms don't like what they call giving out K-1s to a bunch of members. They just like to have one investment in a company, and they will insist that you change, which can be costly both from a legal and an accounting perspective. So just keep that in mind. If you think you are going to be a strong candidate for venture capital funding, starting off as a C Corp may not have its earliest tax advantages, but you're going to have to change anyway. All right, so now I'm going to get into the pitch. And when I talk about this pitch deck, and you all should have a handout, they're in the back, as well as my business cards are in the back as well. This is designed for a situation where it's not so much one-on-one. It's where you're competing in a room like this with potential investors or judges in a room, and you're up at a podium, and you got your PowerPoint, and there's going to be 8 pitches that day. And so you're, maybe the 4th of the day, and you're coming in, you have a 20-minute pitch and 2 minutes or 10 minutes of Q&A. So that's what this deck is about. It could be used in any setting. It could be used for one-on-one. So in that regard, the first slide I say is, who you are and what you do. It's not a detailed description of the business at this point, but it's the person in front of you might have been a cancer drug, and the person after you might be a knee replacement. So just kind of setting the stage of what you're here to talk about today. And the next slide is probably the most important thing, is what is the problem you're solving? It can't be a nice to have kind of thing. It needs to be a must have. You have to convince a potential customer to stop doing what they're doing today and start doing something new. So, and the only way they're going to stop doing what they're doing today and do something new is because you're solving a problem that other people aren't solving, or they can't solve some other way. And you're solving it better, cheaper, faster than anyone else. So Me Too products tend not to get funded so easily. So solving a unique problem in a unique way is very critical to getting outside funding. And then the next is explain how you do it. What's the solution? This is where you can show demos, you can show screenshots, you can show a video, but this is the most fun part for an entrepreneur, because you get to talk about your product. So talk about your product and explain how you go about solving the pain that you laid out. The next is how do other people solve this problem? Or another way of saying that, what's the competitive landscape? And a lot of people say, well, there's really no one solving the problem quite this way. Well, that's usually not true. And remember, the status quo is your biggest competitor. The customer doesn't have to change. They can do what they're doing right now, which may be nothing, but that's still a competitor. You got to get them to change their behavior and buy what you're selling. Next slide is, what is the market? And by that I mean, what is your addressable market? It's not all internet transactions. It's a specific narrow niche of potential customers within usually a much bigger market. So what is the addressable market you're going after? And how do you know that is the most important thing. It can't be anecdotal. You have to show that you've done your homework, you've done research, you've looked at journals, you've talked to potential customers, you've done some level of research to validate the size of your addressable market. Excuse me, as you can tell, I have a sore throat. The next slide is probably the most important slide, and that is how are you going to attack the market, or how are you going to get customers? What no one wants to hear you say is, it's a $2 billion market, if I get 2% of it, I'll be this big. It just goes in one ear and out the other. It's more meat and potatoes of who is your first 50 customers you're going to call on, what's the sales cycle, how are you going to go about calling on those customers, direct sales, channel partners, inside sales, people on the phone, search engine optimization strategies on the internet. But you need to have a strategy for getting customers. And that needs to be very laid out, because if you educate them on how you're going to get customers in the next slide of how you're going to price your product, they're more inclined to believe your 5-year forecast because you've walked them through your assumptions. And if every customer is $1,000 a month and you're going to close 100 customers a month starting in 6 months, you'll be 600,000. So you can kind of do the math and figure out that do their financials make any sense. Your pricing plan, this is also can't be anecdotal. So I can't stress enough about talking with customers and prospects and looking at what competitors charge, and to make sure that your proposed pricing is in line with the market and what customers are willing to pay to solve the problem. And a good way of validating your pricing is, what is the return on investment? There's no magic answer to that, but it sure is a lot easier to sell something if the customer is going to get a 10 times return. So you're going to sell something for $100 and they're going to save $1,000 in the first year. That's a pretty good value proposition. So something along those lines, if they pay you money, what do they get? You're either going to get more revenue or lower cost. And what is that for them, so that you can justify your pricing? Next slide, I talked about a 5-year forecast. Glide asks people for a 3-year forecast, and I tend to tell people to do 5, because after 3 years, companies just don't look big enough. And no one, from an outside funding perspective, wants to fund a lifestyle business. They're looking to fund what they would call a real business. And what I'll call a real business for this definition is, in year 4 or 5, you need to be $15 to $20 million of recurring revenue. If it's a $1 or $2 million business 5 years from now, outsiders aren't going to fund it. So it's got to be sizable enough and be able to grow from there to attract outside funding. And a 5-year forecast tends to give you enough runway to have that come out that way, or bigger. I mean, obviously, be $100 million in 5 years would be better, but as long as the assumptions support that.
Are the slides not ever going to be with us, with the TECHUDSON?
I'm sorry?
The screen doesn't match what you're saying.
No, I don't have a PowerPoint today. I'm just going off of my handout, which is in the back.
Could you repeat that last part about the amount of funding, the size of the business after 3 to 5 years?
After 4 to 5 years of your forecast, the business should have recurring annual revenue of $15 to $20 million, or greater. The next one, I delineate what you need to break even. Typically, you're standing in front of a funding source, and I'll pick on Glide again, and you're asking them for $25,000. They want to know, how much money do you need in total? Because if you're asking them for $25,000, but you need $1 million before you break even, they don't mind that, but they want to understand it, and they want to know what thought you've given to where you're going to get the other $975,000. And typically, entrepreneurs don't have an answer to that, but they can say, I'm applying to Jumpstart, I'm applying to North Coast, I've talked to these 3 angels and kind of soft circled a couple hundred in angel investment, and I think I can raise it over the course of the next year. But if you don't even know, that's a big red flag. So they want to know what you need to operate the business, and that means you got to fund your operating losses. So if you're projecting, which most people do, an operating loss in the first year or 2, and then you have capital equipment purchases or inventory or other cash needs, what's the total amount of money you need before you're able to pay your own bills? And then number 10, personalize your pitch. This is the only slide in this deck that is unique to the audience you're standing in front of. Everything else in this deck you could use in front of any investor anytime. This slide you'd take out and replace with whoever you're in front of. So a Glide, they want a $25,000 project plan. And so they want 4 or 5 milestones with dates, deliverables, and a project and how you're going to spend the $25,000. And they're looking for that to move the ball down the field. They don't like to fund like sales and marketing activities. They like to fund R&D, development, prototyping. They will fund legal fees for patent search. But kind of direct expenses associated with bringing your your product to market or validating the market. Management team. So it's not uncommon that the entrepreneur is the only person in the company, but it's good to have a board of advisors. They don't have to be paid, and they don't have to be a formal board of directors. But to surround yourself with people that fill your weaknesses, and surround yourself with people who have experience in your industry, with your product. Oftentimes people will have a patent attorney or an accountant, but to surround yourself with 4 or 5 people that will support you as the entrepreneur and make what will be a quasi-management team. And they need to be credible, so they can't be relatives or anything like that, but credible outsiders that will keep the entrepreneur challenged and support the direction of the company. Next is exit strategy. Keeping in mind that outside investors are not looking to run a business for 20 years. You may want to do that, and there's nothing wrong with that. But outside investors want to get their money back. And the way they're going to get their money back is you're going to sell the company for a profit, and they're going to get their return, and you're going to get your return, and hopefully you'll move on and build 2 more companies or 5 more companies. But they at least want to know what the exit strategy potential could be, and it's a good idea to cite recent transactions. Like Google bought 3 companies in this same space in the last 2 years and paid 10 times revenue. So thinking about who would find your company irresistible a few years down the road, and then what kind of things have they bought in the last 4 or 5 years to support your assumption. This next slide I like to do, it's called Express Additional Potential, is it's common for a company to have many ideas when they're starting off with one. So I like to tell people to get the audience excited that, hey, once I get this thing up and running and once I'm working on my business plan, I'm going to focus like a laser on what I've been talking to you about today. But down the road, here's 4 or 5 other things I think I can do with this that makes this opportunity even bigger than what I've been talking about. It kind of sets the stage that, okay, you showed me a $20 million a year business plan, but if I like these other 4 or 5 things, this could actually be a lot bigger company than that. So just to kind of get the audience a little bit excited about it. And then finally, to thank the audience for their support and for allowing you to present. And then end the discussion with 3 things that you want them to remember. The idea being that they're probably going to hear 8 presentations that day. So if there's 3 things you want them to remember from yours as a takeaway, re-highlight them in your closing remarks. And then one thing I wish I would have said on here that I didn't is a 15th section, and that is it's okay to have appendix slides. So these are maybe answers to commonly asked questions or objections, or detail on financials, or detail on the product, detail on the market. There's nothing wrong with having them in your appendix that you can flip to if you're asked questions, and you'll have the detail right there. Typically, when you present at these kind of things, they don't like handouts. And so to go around the room and introduce yourself is not something that's available to you. Handouts is not something you can do. So your presentation needs to stand on its own. You don't want to read your presentation, so they can read for themselves, and they hate it when an entrepreneur stands up there and reads all their bullet points. So tell stories. Be a good storyteller and talk about what's the customer's experience today, what's the customer experience going to be like when they start using your product, and highlight those differences and why their experience is going to be so much better. And there'll be plenty of time for specific questions at the end. But the details of the slides, you know, they should just speak for themselves. So one thing I also wanted to mention about preferred angels investors, I just wanted to throw this out so at least you can say you heard it. You may get asked by an angel investor that I want to give you, I want to take preferred stock as opposed to common stock or whatever. So what that means is, say they invested $100,000 in your company and they own 10%. They want to have a preference, meaning they get paid first before you do or anyone else other than the IRS and debt holders. And they're going to want a return on their investment, like say 8%. So let's say you sold the company for $10 million 5 years from now. They get their $100,000 first. They get all those years of 8% first, and then they still get their 10% equity. That is extremely common when dealing with angel investors. So if someone throws that out to you in the course of a discussion, you know, talk to your attorney about it and get counsel, but that is a common thing with angel investors. So with that, I'll sit back down and we'll throw it up to questions for either one of us or both. And welcome your, yes, ma'am. I'm sorry, could you repeat that? Yes, sir. Well, because banks don't do, they don't do financing for companies without revenue or earnings. So if you have assets, collateral, you have hard inventory or machinery, you know, perhaps they would loan money on that. But they, without a personal guarantee and the entrepreneur having their own hard collateral, like a house, they're not going to loan on a company without revenue and earnings. Yes? It's a good program. It requires personal guarantee and collateral. You have to have collateral.
Yeah, the SBA is a loan program. It's
research grants. Yeah, those are great. Those are typically for science-based projects. But yeah, a lot of people get those. It's SBIRs, it's called. And they are for research grants. Typically, they start off about $100,000, and you can get up to $1 million. Yes?
Any word on the ear to the ground since September 23rd? Title II of the Jobs Act was regularized. Has anybody taken advantage of that? And what do you think about Title III?
I think you're referring to the rules on general solicitation and private offerings. So up till September of this year, for those of you who may not be familiar, if you are doing a private offering to investors under Rule 506 of the Regulation D, one of the securities regulations, Rule 506 allows you to raise actually an unlimited amount of capital, and typically to accredited investors, and you are limited to 35 unaccredited investors, and the accredited investor status is basically a net worth calculation. So you are able to put together generally private offering materials, and you pitch this to high net worth individuals. We do them frequently, and most of our clients work through you know, an investment bank or an investment advisor who has a pool of accredited investors or who like to invest in these sort of alternative arrangements to kind of balance out their portfolio. And previously, companies were not able to solicit investors, accredited investors. You had to know someone who knows someone, or like I said, go to a bank or go to someone who has access to your pool of accredited investors. So as of September of this year, the regulations changed, and as long as your offering is limited to accredited investors, you can actually publicly advertise your offering. So I have a couple of clients who are sort of throwing around the idea. You know, I think that one of the issues, and I've read a lot of articles about it, I haven't actually seen any advertisements, you know, no one's advertising in the Wall Street Journal for their private offering at this point. So I think that, you know, there are some platforms, especially online platforms, that appear to be cropping up, and some of the broker-dealers are putting together platforms that will maybe kind of help facilitate, almost if you look at the crowdfunding arena, where you have crowdfunding platforms which aren't equity investments or haven't been up to this point. But I think that, you know, there are some online platforms that are developing sort of an analogous equity platform where investors can go on, learn about a company, and then maybe connect with them if they're interested in participating in the offering. And then what was the second?
Title III.
Do you know what the
That's
subject?
going to be general solicitation to all mom and pop.
Oh, right, the crowdfunding. So there's also a section that actually allows for what you think of as crowdfunding to any investor. You don't have to have the accredited investor status. You know, I think that I've heard a lot of people discuss that it's going to be cost prohibitive. You are going to need to develop, I mean, a private offering is expensive. I mean, you know, generally, if you're working with a broker-dealer who brings you your investors, you're paying them 10% of the funds you raise at least, and then your legal fees are into the tens of thousands of dollars just because of the extensive documentation you need to put together. I mean, I don't know if you've looked at an offering, a private placement memorandum. It's, you know, 100 pages plus of legal disclosures and information about your business, plus the investor questionnaires. There's just a lot of legal documentation that is prepared. So it gets expensive, and the crowdfunding is limited to, I believe, up to $1 million total. And I think, you know, another issue I foresee with the crowdfunding is you know, raise your $1 million, and you now have, let's say, 2,000 people who each, you know, kicked in $5,000 for your raise. You now have that number of equity, you know, basically shareholders that you are accountable to, and you're still a private company. And I think there's issues with, you know, exit strategy, how they're getting in and out of the company, the liquidity. I mean, it's one thing if you're buying publicly traded stock and one of several shareholders. I think that accredited investors who are participating in a private offering maybe have a better feel for some of these issues, whereas, you know, if you open it up to the public in the crowdfunding scenario, I think I guess we'll have to see how it evolves, but I think that there's going to be a lot of applications. I think it's going to be expensive, and then the ongoing disclosure requirements, you're obligated to keep all of those individuals updated on what's going on with the company, you know, sending them updated disclosures as things happen. So that's sort of my thought on it. But
I think a couple things with that. Just for the audience's benefit, an accredited investor is somebody who makes more than $200,000 a year or has $1 million of net worth. So that's kind of what qualifies an accredited investor. But on the crowdfunding piece, she's right, it's going to be very expensive. It could probably cost you $20,000, $30,000 in legal and accounting fees to get that set up. So then you got to pay a commission to a broker. So unless you think you're going to absolutely for sure raise $100,000, I don't see any reason to do it. The other negative to it is no VC is ever going to partner with a company with 2,000 shareholders. So then you got to unravel the whole thing if you're ever going to take on venture capital funding. So they took a good idea and really messed it up, in my opinion, with all this stuff. It could have been fine, but they've just added up all these layers of regulation to it that I don't see. Very few people are going to be able to take advantage of it. Where Kickstarter, on the other hand, is fantastic if you got a product to give away. So if you're not raising money and you build clocks and you want to give somebody a free clock for a donation, it's a great tool. It's a wonderful tool for products or music, or bands do it with their first CD and things like that.
Yeah, I think if you have something that fits into like the Kickstarter product crowdfunding model, then raise as much as you can in that, or I guess I shouldn't say raise as much as you can, that there's also some, you have to be cognizant of how much you're looking to raise, what target you're setting, because if you set a, $100,000 target that's rather arbitrary and you don't get to that point, depending on what platform you're using, you may, not receive any of the funding. So, but I'm just saying that I think the model is better if you can get the capital you need in that model as opposed to trying the equity crowdfunding model, because I think that...
I tried the crowd with a medical device. The people are impatient. They could not wait 2 years to get their return.
Right.
A gift.
Well, now you can't even do that anymore. Pebble Watch stopped that. You actually have to have it built before you can go on Kickstarter now. You used to be able to go out with an idea and then ship it to them when you had it ready, and you can't do that anymore. One thing I forgot to mention on these funds earlier, I'm glad I thought of it, is the Third Frontier, who gives the money from the state to Glide and these other organizations, has some rules about the kind of companies they can fund. And they have to be essentially potentially fast-growing technology-based companies. Doesn't have to be computer technology like software. Could be materials, could be energy, could be biomedical, life sciences products, medical devices, drugs. But it's not cupcake shops and laundromats. So you can't get funded by that with these funds. It's just they're prohibited from doing it. And they're pretty much prohibited from funding consumer products. So things that would go on Amazon and be sold for $29.95. Not that you can't make that a good business, but these funds are not allowed to fund those kinds of things.
George, do they require matching funds?
It depends.
Third Frontier mostly does.
Well, only Glide B requires a $100,000 match. Glide A does not, North Coast does not, Jumpstart does not. Any other questions? Yes, sir.
Have you had any experience where two companies will partner on a joint venture to go for funding? And how does that complicate the matter? Is there one company that has to lead in a joint?
If two companies partner and form a joint venture, that joint venture needs to be an independent company with its own management team. So they're not going to fund Company A and Company B partnering on a project, but both management teams still have their day jobs. They're going to, if Company A and B can form brand new Company C, and one of the two executives can leave his job and start running Company C, or at least have the plans to do so, that's fine. But it can't be commingled within the two companies.
And I think also from a legal perspective, joint ventures can be just tricky unless you have a very extensive sort of contractual joint venture agreement in place that outlines the rights and responsibilities and liabilities of both parties. I agree with George that it's a much cleaner approach to just form a sub, basically, that's owned. Each of the partners own a percentage and handle things that way.
Okay, so our cards are in the back. You're welcome to follow up with emails or phone calls if you have questions after today. And thank you very much for coming.
Thank you.